Hi, so good afternoon to everybody here. I'm delighted to everybody who has joined us for the Miriam Institute webinar taking place this afternoon, New York City time. Thank you so very much for being with us. And there's a lot to dive into today because we are going to be reviewing an academic paper and discussing the paper penned by Professor Jeffrey Korn of Southern Texas Law Center. His paper is entitled The Civilian Risk Exploitation and Indirect Civilian Targeting. It's a fascinating paper. I had an opportunity to review it in full. And we are joined by a very, very esteemed list of panelists. I'm going to run through those individuals. And then after that, I'm going to ask Professor Korn if he would please give us a 10-minute overview of his paper, of his position. And then we're going to bounce it around between the American experience, the Israeli experience in the legal spheres, and then also we will be doing the very same for the operational experience, being joined, as we have the pleasure of being, by Professor or Colonel Liam Collins, a retired officer of the United States Special Forces. So as I do that, I'm just going to ask Alan, until the issue with our fourth panelist, Professor Knoops, is remedied, can you please remove their screen? Thank you very much. So on to the author of the paper. Professor Jeffrey S. Korn is a professor of law at South Texas College of Law in Houston, Texas, and a retired U.S. Army lieutenant colonel. His Army career included service as both an intelligence officer and a military attorney. His last position with the Army was as a senior law of war expert advisor for the Judge Advocate General and chief of the Law of War branch. Prior assignments included chief prosecutor for the 101 Airborne Division, Air Assault, and Regional Defense Council for Western United States, Alaska, and Hawaii. He earned a BA from Hartwick College in Oneonta, New York, a JD with highest honors from George Washington University, and a Masters of Law as the distinguished graduate from the U.S. Army Judge Advocate General School. He's the co-author of The Law of Armed Conflict, An Operational Perspective, The Laws of War and the War on Terror, National Security Law and Policy, Principles and Policy, U.S. Military Operations, Law, Policy and Practice, National Security Law and the Constitution, and Law in War, a concise overview, which he authored with K. Watkin and J. Williamson. That's Professor Korn, the author of our paper. In addition to that, we're delighted to be joined by somebody with a rich and, quite frankly, storied operational history in the United States Army, specifically Special Forces. That's Colonel Liam Collins, retired. Liam Collins is the executive director of the Viola Foundation and the Madison Policy Forum, and a permanent member with the Council on Foreign Relations. A retired Special Forces colonel, Liam served in a variety of special operations assignments and conducted operational deployments to Afghanistan, Iraq, Bosnia, the Horn of Africa, and South America. A defense and security expert, Liam has written numerous articles, reports, and chapters for anthologies focused on terrorism and counterterrorism, insurgency and counterinsurgency, modern war, special operations, organizational innovation, and leadership. His work has been cited by the Assistant to the President for Homeland Security and Counterterrorism, by the White House Press Secretary, the New York Times, the Associated Press, CNN, ABC News, Fox News, NPR, The Wall Street Journal, and USA Today. Liam earned a BS in Mechanical Engineering in Aerospace from the United States Military Academy and a Master in Public Affairs and PhD from the Woodrow Wilson School of Public and International Affairs at Princeton University. Welcome to you, Colonel Collins. It's a real privilege to have you with us. And adding the Israeli perspective to this is a great friend of the Miriam Institute, a great road buddy, and an esteemed speaker and practitioner in his own right. That's Colonel Eli Baron, a retired officer of the Israel Defense Forces within the MAG Corps, the Military Advocate General's Corps. His most recent position was that of Deputy Military Advocate General. Eli concluded his career in the Israel Defense Forces holding the position of instructor at the IDF National Defense College. There, he was tasked with mentoring both the group and individual studies of senior select officials from within Israel and the international community, with a particular focus on matters of national security, strategy, international relations, and economics. Prior to that position, Baron served, as I said, as the Deputy Military Advocate General of the Israel Defense Forces from 2012 to 2015, where he was in command of approximately 1,000 lawyers. And who wouldn't want to be in command of 1,000 lawyers and legal experts? I'm sure everyone would agree, including prior to, during, and following Operation Pillar of Defense in 2012 and Operation Protective Edge in 2014. He also served as the chief legal advisor for the Israel Defense Forces in the West Bank, or Judea and Samaria, from 2009 to 2012. I believe we also have the privilege now, dialing in from Holland, of having Professor Alexander Knoeps with us. Alexander Knoeps is professor by special appointment of politics of international law at the University of Amsterdam and visiting professor of international criminal law at Shandong University in China. He's currently lead counsel in 2 cases before the International Criminal Court and has appeared as lead counsel in cases before the International Criminal Tribunal for Rwanda, the International Criminal Tribunal for the former Yugoslavia, and Special Court for Sierra Leone. And so, ladies and gentlemen, listeners, everybody who's here, it is indeed an esteemed panel. And Professor Knoeps, just for your benefit, thank you so very much for being with us. Thank you so very much for overcoming the technical difficulties. We're going to kick this off with a précis by Professor Korn, author of the paper, and then I will bandy about questions for everybody on the line. Professor Korn, if you would.
So first, thank you, Benjamin. Thank you to the Miriam Institute for giving me this opportunity to talk about the paper, and a special thanks to my colleagues and experts who are going to hopefully help me refine and perhaps improve the concept behind it. So the title of the paper is actually one of the challenges I've had with the paper, as I mentioned to you earlier, Benjamin. I settled on the title Indirect Civilian Targeting after explaining the thesis to my friends Chris Jenks and Eric Jensen. And the origins of the paper really began in 2014 when I was involved in a study of the Gaza conflict that was conducted by 5 retired US Army general officers. One of those general officers was Major General Mike Jones, and we wrote a report on the Gaza conflict and learned from that conflict. And then we did some presentations. And I remember vividly, we were in the United Kingdom. We were doing a presentation in the Parliament building. And General Jones made a comment that just to me really hit home. He said, when I was a young tank officer, I was taught that information was a supporting effort to combat, like intelligence or communications or logistics. He said, what I learned about Hamas studying the conflict in Gaza was that for them, combat is a supporting effort to information. And what he explained was he realized studying the conflict that Hamas never had an expectation of winning the tactical battle. That was just not realistic. Their goal was to cause the type of carnage and destruction that they could then leverage in the international media domain in order to delegitimize the efforts of the IDF and the efforts of Israel to defend itself against the threat. And if we think about the way the conflict progressed in 2014, we see that the images of destruction and civilian injuries and death led to a crescendo of criticism against Israel. And then even coming from the United States, the kind of somewhat infamous comment of the Secretary of State when he said that the attacks could not have been proportional, and the pressure mounted, and of course the operation was terminated. So I'm thinking about what this tactic really involves. Now, we know, the people that study international law know that there is an existing prohibition in the law about using civilians as human shields. It's one of the more pernicious violations of the international law of armed conflict that we can imagine, and probably only one step down from the deliberate attack on civilians or civilian property, which is also prohibited. And as I'm sure Professor Knoeps will note, it's a crime that is codified in the statute for the International Criminal. But what I started to wonder was whether or not we are under condemning, if you will, the exploitation of civilians by constantly characterizing that exploitation as human shielding. If you think about the word shield, the idea is that it protects something. The idea behind the notion of human shielding is that you are illicitly using the presence of the civilian population to deter the enemy from attacking vital military objectives. And there's no question that that conduct occurs in hostilities, and it is a tactic that's used by illicit armed groups in order to negate the more effective combat power of their opponents. But I think what General Jones was getting at was something that was even more pernicious, and that is the use of civilians to bait the other side in the conflict to actually launch the attack with the knowledge, expectation, and in my view, the hope that the attack will actually cause civilian injury and harm. And then that civilian injury and harm can be exploited in the international information domain, particularly because one of the hardest things to understand about the law of armed conflict is that the law does not prohibit the knowing infliction of death or injury on civilians. What the law prohibits is deliberately attacking civilians or civilian property. But the principle of proportionality presupposes the legality of inflicting collateral damage and incidental injury when you're attacking an otherwise lawful objective, so long as that incidental injury and collateral damage is not assessed as excessive in relation to the military advantage. So what I started to think about was, is there a better way to capture the true essence of an abuse of the presence of civilians, not necessarily to shield the target from attack, but actually in the hopes that the other side will feel compelled to attack the target and thereby not just destroy the target, but inevitably cause civilian death or injury or destruction to civilian property. The problem, as I see it, when I think about this, is that when the international community assesses the legality and morality of military operations today, there is a strong tendency to engage in what I've called effects-based condemnations. What I mean by that is we look at the effects of the attack and we draw an inference that it must have been illegal because of the level of civilian destruction or harm to civilians. But people like Colonel Barone know that that's not the way the law is implemented. To implement the law effectively, you have to step back and conduct an ex ante analysis of the attack, figure out what the value of the target was, figure out what the anticipated civilian risk was, figure out what precautionary measures were implemented, and then make a judgment about whether the judgment of the attacking commander under the circumstances was reasonable or unreasonable. That is a far more complex equation and not one that is very easy to translate to a 2-minute soundbite on the evening news. So what I was thinking about when I started to write this paper is, how can we better characterize the deliberate exploitation of civilian injury or death by changing the terminology a little bit and moving away from the notion of human shielding to actually an attack on the civilians. That brought to my mind I teach criminal law, and in the common law criminal law system, there's a doctrine called innocent instrumentality. It's a very interesting doctrine where you attribute action of an innocent agent to a defendant who baited that agent into conducting that action with an illicit purpose, with a criminal mental state. So the example would be, you want your neighbor killed, so you make a false report to the police that your neighbor is armed and dangerous, hoping that the police will respond and use force to defend themselves that is reasonable from the perspective of the police officer, because you've created the conditions that make that use of force inevitable. So this notion of using an innocent instrumentality seemed to me to be a logical way of characterizing the use of civilians in a way that will create a risk that they'll be killed or injured by baiting the other side into conducting an otherwise lawful attack. And why I think this is important is because by explaining it in these terms, it requires the attacking force to emphasize and indicate why the attack was lawful, even though there was an expectation of civilian harm. And what I'm trying to do is move away from the assumption that direct cause always equals legal responsibility. So what I mean by that is if there's an attack on a target and civilians are killed, it's very easy to identify the direct cause. The direct cause was the bomb that was dropped that caused the explosion. But what we know in modern warfare, particularly with enemies that seek to delegitimize their opponents, is that in many cases, the legal responsibility for that civilian injury falls at the feet of the defending force, even though the direct or immediate cause was the attacking force. So what I'm trying to do in this paper is come up with a theory that highlights or emphasizes the importance of separating direct cause from legal responsibility and doing a much more careful assessment of where legal responsibility falls. And one more point, the reason this is so important is because what legitimate democracies have learned in the past 20 or 30 years is that legitimacy is a fundamental strategic imperative in the conduct of military operations. That's what General Jones understood. And in fact, legitimacy has been elevated to a fundamental principle of joint military operations in US military doctrine, in Joint Publication 3-0, which defines the doctrine for joint operations. 3-0 defines legitimacy as the actual and perceived legality and morality of military action. So it's not just the actual legality. We can defend actual legality. What we have to do, I think, is come up with better mechanisms to demonstrate the perception of legality, even when an attack results in death or destruction to civilians or civilian property.
Thank you, Professor Korn. So before I start to bounce this around, as I said that I would, I want to commend you on this. It's absolutely of high interest to me as a veteran of service in the Israel Defense Forces, as somebody who's served in a military that's oftentimes pilloried in the court of international public opinion. And so I thank you for doing this, and thank you for continuing my education. I want to bring our audience into some real life examples of 2 points that are central to your paper. And I think that the best person to begin with is actually Colonel Collins. Colonel, so the professor has called this, as distinct from human shielding, he's called this indirect civilian targeting, to repeat, to move people into a position where they are likely to be killed, possibly will be killed, and that will have a social advantage in terms of social media, a rush to prosecution and judgment by the court of international public opinion, and therefore it needs to be a category in and of itself. It's not passive, it's the active engagement and facilitation of the killing of civilians. And correct me if I'm wrong there, Professor Korn. Colonel, I'd like to know if you can give us some examples from your experience in Iraq and Afghanistan, if you would, of indirect civilian targeting as defined by Professor Korn, rather than human shields.
There probably for tactical protection as opposed to baiting, though I think baiting is still a potential use of it. In Ukraine, we've seen the Russians, or the Russian-led insurgents in the east in the Donbass region, deliberately having the insurgents plant, you place your artillery weapon systems right near schools or hospitals, right? And I think that's more for tactical protection, realizing the Ukrainians aren't going to open up on their own citizens right there and put them at risk. But no doubt, if it was to bait, they're going to take advantage of that in terms of their information operations perspective. And then kind of, more recently, right, the use of human shields, as he already addressed, kind of by Hamas in Israel. But we've seen it other places too, in Sri Lanka, right? It was pretty common tactic of the LTTE, or the Tamil Tigers, right, to kind of use their family members to travel with them as human shields to bait the enemy into attacking them, and then they what would do is bring up so much international, right, would push them then to kind of to a ceasefire, and then kind of give them space to breathe. Ultimately, they lost because at the kind of the final battle or final kind of stage of the conflict, it was passed post 9/11, and there really was no international condemnation against it. And so despite their efforts to bait them, it didn't work in terms of their perspective. And so I'd agree that human shields are going to increase in the future due to trends in population growth, urbanization, and so welcome thoughts on how to curb it. And so I really think it's really about strategic communications or information operations or whatever term you want to use. And not only is Hamas great at it, but the Russians are great at it too. They really view it as kind of a main effort, and kind of kinetic or conventional forces kind of as a supporting effort to it. And so many commanders, won't act, not only out of fear, potentially, right, they won't be baited, or if they are baited, right, they won't act oftentimes, right, out of the negative information operations. But I think also, I suspect because of psychological blame to their self, much like a police officer might be baited, right? And so we need to give legal assistance to them, right, so that they know that they are innocent, right, provided it was necessary and proportional. But in terms of Iraq, right, where we see it play out, the first Battle of Fallujah in 2003, right, the Marines were kind of advancing into and taking control of the city, and then out of nowhere, right, surprisingly, it was told to kind of cease the advance, and the operation was halted. Why? Because of the perception of civilian casualties in the city, despite the fact most of the civilian population had left, and it was primarily just insurgents left in the city. Nevertheless, right, the kind of that information operation that was playing out kind of halted the advance in the Battle of Fallujah and caused us to stop it.
Thank you very much. And so you've given examples there of Sri Lanka and Ukraine and Hamas and Russia. Before I move on to our other experts on this call, Professor Korn, I think it's very important that everybody clearly understands this notion that you put forth of innocent instrumentality and your desire to extrapolate from that for the purpose of the laws of armed conflict. Now, there's a wonderful example that really crystallized this in my mind that I'd ask you to speak to, and that's this example of Bailey versus the Commonwealth. Can you just talk about that? Because it goes to the heart of an individual with criminal intent utilizing a legitimate act in order to carry out that criminal intent and not being absolved of it as a result of that fact. Can you talk about it?
It's a very sad case. It's taught in a lot of criminal law textbooks in the United States. So here's what happens. You have two individuals who are bickering with each other on ham radio. I mean, you really can't make this stuff up in criminal law. They don't like each other. They live in the same community and they know that. One of them is legally blind and the other one knows it. And the one who's legally blind also adores General Patton. So one night, the other one, to provoke him, starts being disrespectful about General Patton. And the one who's legally blind says to him, "I dare you to come and say that to my face." And the other guy says, "Well, I'm going to come." And the legally blind ends up being the victim, says, "I'll be waiting for you on the front porch with my shotgun." So the other guy calls the police and says to the police, "There's a crazy guy on his front porch with a shotgun threatening people." The police, unaware that this was a setup, respond to the call. They get to the house. Obviously, the guy who's legally blind hears a car pull up and the door open, and the officer says, "Drop your gun." And the legally blind victim, assuming it's his antagonist, raises the shotgun and the police shoot and kill him. So the person who baited the police into doing this is brought to trial for criminal homicide. He says, "I can't be guilty of criminal homicide because I didn't shoot anybody." And he says, "And I can't be an accomplice because you can only be an accomplice to an unlawful act. And what the police officers did was a lawful act of self-defense. So there's no unlawful killing for you to attribute to me." And the court adopts this old common law doctrine when it says, when an individual uses an innocent agent to perform their criminal act, that act is attributed to them as if they did it. And what makes the agent innocent in this context? The fact that the agent was acting lawfully. And when I read that case, to me, that is exactly the issue that I see being played out. There's a lawful attack on a lawful target, knowing that it's going to result in civilian casualties, baited by an enemy who intends for those casualties to occur. The attribution of the attack should be to the enemy. They are using the attacking force, the IDF, the US, whoever it may be, as their innocent agent, their agent to conduct an attack on their own civilian population. And it just made perfect sense to me. By the way, let me make one comment in response to Colonel Collins. I just finished reading a book by Mark Bowden about the Battle of Hue in Vietnam. And one of the points he makes at the end was the coverage of that battle focused on casualties, US casualties and enemy casualties. And nobody paid attention to the people who suffered the most casualties, the civilian population in that ancient city in Vietnam, who suffered far more than either side. And he said, and it's such a drastic difference from the way war is reported today. So in Vietnam, in an urban battle, the media didn't pay attention to civilian casualties. Today, if you inflict 2 civilian casualties, it's your strategic Achilles heel.
Thank you very much. And I want to now bring in Colonel Baron. I'm very pleased that you've clarified that principle because it's absolutely central to your thesis as I read it. So Colonel Baron, Professor Korn's gone to great lengths really to ensure that there's a distinction made between human shielding, which might be the crowding of civilians around a target in order to avoid a strike, right? In order to avoid a strike or avert a strike, versus the crowding of civilians around a target with a view to those civilians being indirectly targeted by the attacking force. And I want to emphasize in your terminology in your paper, Professor Korn, when you speak about an attacking force, you don't attribute necessarily good or bad, but can you just clarify that before I ask my question of Colonel Baron? Because I think attacking force might have some connotations, which I don't think are necessarily what you mean.
No, well, I mean, when I use the term attacking force, the inference or the assumption is that it's a lawful attack being launched against a lawful target that will result in civilian casualties.
Thank you. So Colonel Baron, it strikes me as we've looked at many campaigns during your career in the Mag Corps, that there's this new level that's been reached by way of the marches towards the Gazan fence, the Israel-Gaza border. That seems to really be the absolute paradigmatic example of indirectly killing civilians. These people are sent forward in order to be targeted by the Israel Defense Forces and so forth. Do you see that as the best example Israel has of Professor Korn's thesis, or would you like to invoke other points or supplemental points?
Sure. So let me just start by thanking you, Benjamin, for extending the invitation to be a panelist on this webinar. And obviously you have a very distinguished group of panelists. I think Jeff's thesis is admirable because it makes a commendable attempt to tackle one of the modern laws of armed conflict's biggest challenges, and to justly put both the moral and the legal responsibility for the death of civilians who are being abused as human shields on the shoulders of the party that abused them. And as you mentioned, Israel has contended with this challenge for years now, both in Lebanon with Hezbollah and in Gaza in all of the military campaigns with Hamas. In fact, if you look at the modus operandi of Hamas, the whole setup, the whole setting of the combat arena in Gaza is being put in a way that is everything is being around the concept of human shielding. And in fact, it got to a point where human shielding is the rule rather than the exception. So when you even read the manual combats of Hamas, it is very clear that this is the way they instruct their combatants to engage in war. They talk about both aspects of human shielding. For them, it's a scenario of heads I win, tails you lose. meaning either we deter the IDF from attacking our military assets, or they will attack our military assets, and we will be in the what Jeff calls the information campaign. Let me just quote one specific quote from these Hamas manuals, in which they say, civilian deaths have no impact on our morale. To the contrary, this strengthens our commitment in the knowledge that an increase in the number of civilian fatalities is likely to have negative ramifications on the enemy, and he will act to shorten the length of the fighting. So obviously, it is very clear to them, as it is clear to us, that civilian casualties will be a consequence of this modus operandi of abusing human shields. And this is clearly something they bear in mind when they use these tactics again and again in the battlefield. So you asked Benjamin about the use of these human shields in the on the Gaza border, in the Gaza riots. I mean, the number of casualties on these riots has not been as high as it is in fully fledged military campaigns, as we've seen in the 2014 military campaign, for instance. But it is most definitely the linchpin of the tactics of Hamas throughout these riots for 2 years. So in these riots, they will commingle children and women and elderly people among their combatants, their militants. They will send them to the fence line with Israel, and obviously, in the eyes of the IDF soldiers on the other side of the fence, there's just a very big group of people. Most of them are maybe just protesters, but they do know, and they sometimes can identify Hamas militants among them. They all storm to the fence, and they try to make use of this huge group of people to infiltrate Israel and carry out military attacks inside Israel. Obviously, some of these people, of these protesters, also get hurt in the military effort to stop these crowds from crossing the border. And this is yet just another example of human shields. But if I may, I would like to address maybe some of the issues that Jeff's thesis raises. I think, first of all, I think that the idea of using the doctrine of the agency, of innocence agency in this issue is just beautiful, legally beautiful. I'm not sure that that we will have the result we want in the court of public opinion, because it is, after all, a complicated legal doctrine, and people in the world will, to talk about with the media or human rights groups, they will still put the blame on the shoulders of the militaries of democracies. It is very clear that this happens again and again. The legalistic argument regarding those decisions in making decisions about proportionality issues are always too complex for them to contend with. But I do think that in the legal sense of this, this doctrine can be very useful. I think one of the biggest challenges will be to show how exactly we prove that the enemy really wanted those human shields to die. Obviously, that we will have many challenges disclosing the intelligence we had. A lot of this intelligence will be classified. A lot of it will be inadmissible in criminal courts. I think we need to think about whether it makes any difference if they were hoping they will not die, but still took the chance with open eyes and clear mind, or really wanted them to die. Obviously, when you look at their the process of their decision making, they do not know what is the formula that the IDF commanders use in making proportionality decisions. Obviously, we also don't know them now because it's not a mathematical formula. It depends on many factors, and to my mind, the very fact that they know that eventually, in some scenarios, the IDF will come to the point where they decide that the collateral damage is proportional and the attack will be carried out. I think this equals knowledge that they knew that those human shields are going to die. I wonder, Professor Korn, what will be the result in case if the attack will be disproportionate? Obviously, in order to apply the doctrine of the doctrine you referred to, of this agency, this innocent agency, the attack needs to be lawful. But what happens if the attack is not lawful? If that's the case, can we hold Hamas in this case responsible as an accomplice or a co-perpetrator for the attack with the IDF? That's something we can also think about. I think obviously the doctrine takes into account the fact that these human shields are involuntary human shields. I think and should be stressed because if they are voluntary, arguably they might be discounted from the proportionality calculation, being civilians who are directly participating in hostilities. And this is another factor we should think about in this.
Before I hand that over, thank you, Colonel Baron, to you, Professor Korn. I want to ask two questions in order. The first of Professor Knoop. So there seems to be, Professor, an underlying issue here that maybe you can talk to Professor Korn about, which is the idea of holding people to the standard that they are flouting, right? So they're dealing with indirect civilian targeting. But these presumably are parties who couldn't care less about international law, couldn't care less about laws of armed conflict and so on and so forth. What exactly are the opportunities for prosecution and proof in a scenario such as the one that Professor Korn's spoken about? And does it have relevance for conventional militaries, or is it exclusive in your reading of it? And Professor Korn, I'll come back to you about that. Or is it exclusive to non-state actors or terror organizations? And then Colonel Collins, based on what the professor says, I'm going to come back to you about the measures of mitigation that a field commander has to take in order to retain the legality of their attack. Because I wonder, is there a point whereby a military commander is going to such efforts to avoid civilian casualties on the other side that he's actually endangering, he or she is endangering the lives knowingly of the soldiers beneath their command, and how we navigate that. So Professor Knoop, if you could speak to that for a moment, and then I'll hand it back to Colonel Collins, and Professor Korn, you can summarize that. I think Professor Knoop, you're muted. You're still muted. Great, you're on.
Now I think I'm unmuted.
We can hear you.
Thank you. Thank you, Mr. Anthony, for the invitation, and congratulations, Professor Korn, for your excellent paper. I very much enjoyed reading it. On the question of Mr. Anthony, what is the potential prosecutorial scope in this area? Looking from, and that's how I read your paper with great interest. My purpose when reading the paper was to answer the question, what could a prosecutor at, for instance, the International Criminal Court do with the doctrine of innocent instrumentality? First of all, it's to be noticed that there is no jurisprudence yet developed by any international criminal tribunal whatsoever on the implementation of this common law doctrine into one of the statutes of, for instance, the Tribunal for the former Yugoslavia, the Tribunal for Rwanda, etc. It is certainly also, when you look at the case law in the United States, Mr. Anthony mentioned and you explained the precedent set by Bailey versus Commonwealth in 1985. The Supreme Court of Virginia was, I think, the only judicial body until so far in the United States who applied this doctrine on that level. I'm not familiar, maybe you are, Professor Korn, with a ruling of the US Supreme Court on the viability of that doctrine within common law, the doctrine of innocent instrumentality. But if we look at the international criminal tribunals, such as the International Criminal Court now in The Hague, there is no precedent yet set on the implementation of such a doctrine. Therefore, to qualify the person using an innocent agent, so to speak, as an instrument for a crime, not being an accomplice, but being a principal perpetrator, that application of that doctrine in this sense has not been applied yet by a prosecutor at that level. It could become quite relevant now. As you all know, the ICC prosecutor, Ms. Bensouda, is currently asking for an investigation into the situation of Palestine. And in that case, the pre-trial chamber of the ICC will render probably in July a ruling on jurisdiction. Now let us suppose that the pre-trial chamber, comprised of 3 judges, would grant the prosecution to start a formal investigation into the situation in Palestine. The ICC prosecutor already announced that it would also investigate not only the military operations of the IDF in the operations in the last Gaza war, but also into the operations of Hamas. And therefore, that could be the first case whereby the prosecutor of the International Criminal Court could start a formal investigation in the use of human shields. The use of human shields has been mentioned in several cases at the ICC, not in terms of charges, but predominantly in the terms of contextual arguments. In one of my cases in West Africa, it was mentioned in one of the witness statements, the use of human shields, but the prosecutor didn't choose to implement that phenomenon in the charges. So, to answer the question, Mr. Anthony, the prosecution under the statute of the International Criminal Court, as far as I can see it and interpret it, has the tools to implement this doctrine of the innocent instrumentality, to apply that doctrine in the modes of liability, which are included in the Rome Statute, as Professor Korn already indicated in Article 25, the sections 3A and 3B. That would indeed ask for an extensive interpretation of the law. But as we know from previous decisions, the ICC chambers have been involved in an extensive interpretation of Article 25 by also including the new liability form of indirect co-perpetration, which is not mentioned in the statute as such, but is being based on jurisprudence of the trial chambers. So, to be brief, the prosecution has the discretionary power to prosecute for the use of human shields, of course. That's already a war crime mentioned in Article 8 of the ICC statute. When it concerns the liability modes, could the theory of being a principal perpetrator based on the doctrine of innocent instrumentality be applied instead of accusing such an individual as being accessory, an accomplice? Yes, that's possible. No, there is no case law yet that could serve as precedent, but indeed, it could be one of the cases, the upcoming cases in the future at the ICC, presupposed, of course, that the prosecutor of the ICC would retain jurisdiction from the pre-trial chamber in July in the situation of Palestine. And the prosecutor already announced that if it would be granted access to a formal investigation into the situation of Palestine, including the Operation Protective Edge, it would most likely also indict leaders of Hamas for the use of human shields. Now, that could be a very challenging situation for the prosecutor, how she will formulate any charges. Will she indeed apply the doctrine, as Professor Korn set out, common law doctrine of the innocent instrumentality? His paper could be very interesting, I think, for the ICC prosecutor. It could perhaps even serve as an amicus curiae brief in the near future for the prosecutor to expand on the liability modes, which are formally very limited in the statute, Article 25, but as just observed, the judges already expanded on those formal liability modes in Article 25 by using its powers as judges to actually extensivate the liability modes with the form of indirect co-perpetration. It's a long answer to maybe a very brief question of Mr. Anthony.
No, I very much appreciate it, because that's something that a number of our viewers have actually emailed questions in about, and it was actually very much on my mind. Before I come to Colonel Collins for the answer to the question, Professor Korn, do you want to respond to anything that Professor Knut just said?
Yeah, and also to Ellie a little bit. It's interesting, when I started the paper, I was thinking mainly about the applicability or the relevance of the doctrine in an international criminal law context, but as it evolved, I moved more towards kind of the information legitimacy aspect of the doctrine. In other words, I think that in many ways, if I were a prosecutor and I had a case of human shielding, I'm not sure I would be particularly attracted to this doctrine, because I'd ask why? Why do I have to complicate things? If I can prove that the civilians were used as a human shield, it's a lower bar and it's a crime. I mean, there's a part of me that says if you're deliberately exploiting the civilians to get them killed, that's deliberately attacking civilians, and I think it's a more aggravated crime than human shielding. But the pragmatic reality is, at the ICC level, I don't think you need it, I guess is my point. Now, I do think there's value, though, because Ellie, you raised the same point. I mean, how do we? It's going to be hard to prove the scienter, the criminal motivation for the use of the civilians. How are you going to prove that they weren't trying to shield, they were actually trying to get somebody killed? Well, I think it's interesting, kind of the legitimacy ping pong game that goes on. If you accuse them of using your forces to attack their own civilians, you know, the first message is, let's be very clear here. They weren't just shielding their forces. They wanted us to attack in order to kill civilians. What defense? Defense is, no, I was just trying to shield my target with civilians. It basically forces the enemy to concede the kind of lesser included offense of human shielding. And I think there's value there. I completely agree with you, Ellie, and I put it in the paper that the Achilles heel of the theory is proof of the enemy's criminal mental state, so to speak. And I think that, as I said in the paper, I don't have all the answers to that. I think it's something that we should start thinking about. So, for example, if you have an area in an urban fight where the enemy tells the civilian population, you are not allowed to leave. We're not letting you leave. If you try and leave, you're a traitor. They don't know exactly what the targets are that we're going to hit in that area, but they know we're coming. And they know that when we come, civilians are going to get killed. What is the inference you draw from the fact that they are prohibiting the civilian population from evacuating a certain area, knowing full well that we're about to attack? I think the inference is clear. They want to get civilians killed or injured. It's not, or in the example that Colonel Collins brought up, you take a high value target. You're conducting a mortar attack against our forces. You know we're going to use counter battery fire to stop that mortar attack. There's 100 places you could put the mortar, but you put it in the compound of a kindergarten. I mean, the inference to me seems strong there. Maybe not conclusive enough to reach a level of criminal culpability, but certainly more likely than not that your goal was to get civilians killed. And so I think part of the messaging has to be, there are situations where we're going to say, they were using us to attack their own civilians. We didn't attack the civilians, they attacked the civilians. And one more point, Ellie, you bring up the point about what if it's a disproportionate attack? In other words, what if it turns out our attack is illegal? Actually, I think there's another criminal law doctrine that answers that question, and it's the doctrine of substantial cause. So a substantial factor. When you have multiple actors that engage in illegal conduct that produce the same result, they're all equally culpable for causing that result. So that actually, I think, could be important because it would enable us to say, look, we've done a credible investigation. We've concluded we shouldn't have launched the attack, and we'll take appropriate action. But they're just as culpable for the harm because they're the one who put them proximate to the target that led to that judgment.
So Colonel Collins, I want to come back to this point, and thank you, Professor Korn, for responding to Professor Knoops and Colonel Baron. I want to come back to this point that Professor Korn seems to have within his paper, which is that deliberately targeting civilians raises, because it's based and predicated upon the idea that the attacking force is engaged in a legal act, it can also have the effect of raising the level or the barrier when it comes to the assessment of the commander in the field to ensure that the attack is indeed legitimate, is indeed legal, and a legal deployment of force. But that raises an issue for me, which is there a point at which a commander, a field commander, is so engaged, as I asked you earlier, in ensuring the legality of their attack, the proportionality of their attack, that they're actually perhaps compromising the safety of their troops who are under their charge, which may or may not be legal, I actually don't know. Have you come across situations and scenarios like that?
1991 Gulf War, right, set unrealistic expectations of civilian casualties in a war, right, and the capabilities of technology in modern war. Unfortunately, most modern wars aren't fought as tank battles in the desert where nobody lives, right? The enemies learn from this. It's not a good way to engage a Western army. So no one's dumb enough to fight in that way, right? And so this is why we see the human shielding, and more specifically, the baiting of it, right? So an example of it again in Iraq, early on in 2003 in Iraq, the 82nd Airborne in Ramadi, which is part of the Sunni Triangle, one of where more of the insurgent attacks were occurring. Right, you've got the 82nd Airborne there in the city, and a large crowd of people, and the insurgents fire from the crowd, right, deliberately baiting the 82nd into returning fire on them, which they did, right. And at that point, right, they alienated the civilian population, who assigned blame to the U.S. soldiers, not to the blame to the insurgents that were firing from within the population, and so they pretty much lost the population at that point. Really, at least until the 82nd left, and really, yeah, I'm not sure we ever got it back, if we ever had it to begin with, but that pretty much, they knew what they were doing, deliberately baiting. In terms of how does this factor into a commander's decision, right? Returning to kind of the artillery example, right? If you put up a mortar or an artillery piece, you could be firing from a mile or 2 miles away, right? Ideally, you want to just return fire to them, minimal risk to your force. But now commanders, if they're overly concerned about how is this, I'm being baited to attack civilians, I don't want to kill civilians, Now, instead of just doing it from farther away, I have to send my forces. Maybe they've got to travel 2 miles to get there, fight through improvised explosive devices, IEDs, and then when they get there, fight kind of the handing. But the battle in the urban environment, clearing rooms to get there, putting them at significantly greater risk that they would never do if they weren't worried about kind of being baited. And it really comes down to, I agree with Professor Korn, you need the legal backing to it, but it's not the legality that matters. It's the information operations, right? And you think about three populations you're trying that need to be influenced, right? You've got the domestic population of where the fight is being fought, right? Fallujah or Ramadi or somewhere in Israel, right? You've got the home population, in this case, the home population of the US saying, oh my God, we can no longer be in this fight because we're inflicting too many civilian casualties. And then you have the international population that's gonna weigh in and kind of cause you to pull back, right? And so I think if this can help in terms of that information operations and the framing, even if you can't get the domestic population of where the fight is being fought, the home population and the international population, that's enough, I think, to help get you there. And then I think eventually things will, we see norms kind of move over time, and it might start influencing that home population.
Thank you very much. And I want to ask Ellie, and Colonel, I'm going to come back to you with some other questions, Colonel Collins. If there are any electrons, incidentally, I heard you perfectly, and I hope everyone else did, but if there are any electrons around your device, could you just distance them while I speak to Ellie? But Ellie, I just wanted to know if you had a response to what Colonel Korn said to you about this idea of not having all of the answers, not having all of the final analyses in hand yet, and whether you see any further pitfalls, or whether his response to you actually answered some of the issues that you raised.
Well, Jeff did refer to my question. I think, let me put it like this. I don't think that in most cases, I don't think when Hamas, for instance, puts those human shields near the target or inside the target, I don't think they want them to die. In most cases, they just prefer us not to attack. But they have to take into consideration, and they do, that in some cases, they do deter us from attacking. And in other cases, we just make our proportionality analysis, and we come to a conclusion, a decision, that the attack will be proportional, and we carry out the attack. When they know that this is one reasonable application result of this analysis, I think this knowledge equals the volition of or them wanting those civilians to die. Okay, so you could say that they don't want them to die, but they're indifferent to their death. They take it as a reasonable outcome of these tactics, and in this under these circumstances, I think it equals knowing that they will die. Let me just maybe refer just very briefly to what this whole means for military commanders, because the whole setting of fighting in places like Gaza, for military commanders, that's a nightmare, okay? No commander will ever tell you that he prefers fighting in urban surroundings when there are so many civilians around him. All commanders always will prefer to fight in an arena, in a combat arena, which is pure, when they don't have to, when they only see combatants in front of them, military assets. They don't need to make all these complicated proportionality analysis. This is very simple, okay? And this is why this the use of human shields is being employed so often by these groups. They know that this is the underbelly of democracy's militaries. They know how sensitive we are to civilian deaths. And they also know that there is very little chance for us to explain all the complexities that surround our process of making the decisions, all the precautions that we take. Let me just give you one example, because we talked about the media and human rights groups, but just last week, I came across a report by the special representative of the UN Secretary General to Libya. And she's she's a prominent and experienced American diplomat. And she refers to the fact that since April 1st to May 18th, I think it was, there were 200 and something civilian casualties in the fighting in Libya. And then she says, and those responsible for the war crimes must be brought to justice. Now, I have no idea whether all or any of these attacks in which all those civilians died were lawful, or were they indeed carried out throughout in the process of committing a war crime. But I do know that the assumption, the unsubstantiated assumption that civilian death equals a war crime, that's a huge mistake. That's a reckless assumption. It's usually baseless, and we heard that from an experienced diplomat. So I do know that the challenge for explaining all of that is immense, but we're never exempt from doing that, because this is the truth. If we want to fight for a reality in which human lives are spared from these atrocities, mm-hmm. we have to raise the public awareness of these realities and these abuses of human lives by these groups.
So I thank you, Colonel. I want to conclude this conversation within 10 minutes. I want to come back, however, to Colonel Collins, and I'm hoping that there's no interference there. Colonel Collins, as an operational commander, do you feel supportive of the thesis put forward by Professor Korn? Is there a need now? Professor Korn's got an amazing line in his paper, which is that as the incidence of urban warfare increase, the complexity of warfare, especially surrounding these issues, is going to increase as well. And that's something that Professor Knoops has alluded to, and of course Colonel Baron as well. With that in mind, do you feel that the forces on the ground need to have these sorts of distinctions, need to be educated on these sorts of distinctions? Does it have teeth in the theater of combat?
Yeah, I mean, like I said, I think this really comes down to kind of the court of public opinion, and then that's what also, commanders are basing their decisions on, is how is this going to play out in that court of public opinion within those three audiences. So I think it definitely has merit, and you're going to see this more likely as we get to more urban. And again, I kind of hinted about technology before, but I think as you get newer and newer technologies, there's this expectation that you can now reduce civilian casualties with it. Reduce but not eliminate, right? There's no way to do that. And so I think it does give commanders that ability, plus the assessment of the blame, right? Where right now it's kind of an established norm, and it's really, right, assigning that responsibility. It's not collateral damage. This is indirect targeting by the enemy, and framing it in that way frees commanders up, so maybe they don't have to might assume that long-term guilt of killing civilians that they were legally and morally able to kill in the conduct of war is necessary, within being proportionable and reasonable. But providing that mechanism, right, not only for the international opinion, but also at the individual level, letting them understand that, no, this is not collateral damage. This was indirect targeting by the enemy. And so I think it has a lot of merit.
Benjamin, can I jump in there?
Yes, please, Professor.
I think one of the issues that we all, I think everybody in this seminar feels intuitively, but might not be intuitive for people who are watching, is the impact of how we characterize incidents of civilian casualties on the moral integrity of the war fighters themselves and the commanders. I think when you think about the burden that we place on the shoulder of a commander to authorize an attack with full knowledge that there's no possible way to avoid harming or killing civilians, that is something that's very difficult to execute and to live with. And we need to understand that. And this attribution of responsibility an important component of giving the warfighters themselves a rational way of reconciling the mortal and destructive consequences of their action that they're taking lawfully. They're satisfied it's lawful. They've done everything they can to mitigate civilian risk, but you're dealing with an enemy that's completely different. So I think matter. They matter not just from an international criminal law standpoint, matter not just from an international legitimacy standpoint, they matter for the moral integrity of the people we ask to do the fighting for us, and typically the commanders who bear that very difficult burden of having to make the decision to launch an attack when an enemy has created a situation where there's no way to do it without avoiding civilian casualties.
So I think that that's a very important point, and I'm going to ask you to make a concluding statement, Professor Korn, but I want to get Professor Knoops in on just one issue, if you can. And Professor, I'll appeal to you to be brief with your response. It strikes me that the United States military is deployed all over the world. We have here a veteran of theaters, including Iraq and Afghanistan, the Horn of Africa, and many more. Obviously, the Israel Defense Forces is constantly dealing with the issue of urban warfare and the buildup of military assets within a civilian population and civilian possessions and assets. But when you look to Europe, it seems that their forces are engaged not nearly to the same degree in any such thing. Is there always going to be a disconnect between the attitude to these issues among Europeans and governments within the European Union, simply because they don't have the same experience and the same imperative, if you like, to grapple with these issues in the modern day theatre of war? And how might you be able to bridge that? And could this paper be instructive in bridging it? And I know that I said I'll appeal to you to be brief. Forgive me, I'll just reiterate that. You are muted again, Professor Knoops. If you just unmute.
Yes.
Thank you.
Thank you, Mr. Anthony. Very briefly on the question, also in relation to the last remark, Professor Korn, about the moral integrity, and also maybe the answer why in Europe there is a different perception on urban warfare in terms of moral integrity and also criminal liability. I think that's very much important if you have military operations which are not deemed to be excessive and the prosecution is not pushing for a prosecution. The doctrine Professor Korn set forth could still be viable to make the individuals accountable who actually induce the innocent forces to engage in military operations whereby civilians are killed, albeit not excessive. So it's not just, I think, a matter of legitimacy. It could also, while knowing there are criminal prosecutions possible, it could reinforce also the moral integrity feelings of the fighting forces. The discrepancy between Europe, apparent discrepancy between Europe and other countries when it concerns urban warfare, I think in Europe, the liability of military officers has been increased basically also on the basis of the jurisprudence of the international courts. And that's why I think there is a great reluctancy in the European armies. I myself, I'm a reserve officer at the Royal Marines in the Netherlands. And my experience is also that urban warfare is something which is very difficult to deal with in Europe. It's not only an issue of mentality difference, but also an issue of military law, which is very, very much stringent. And there are prosecutions being set to commanders here in Europe, which were engaging in types of urban warfare. So I think it's a combination of a different mentality, but also a matter of increase of criminal liability for military commanders under the umbrella of the international laws, which are implemented in almost European states.
Thank you very much for that. I want to ask Professor Korn to come in with a concluding statement. And just to reiterate, there's this clarifying passage within your paper, Professor, And it says the characterization will only be credible based on information that establishes three essential findings. First, that the civilians or protected persons were exploited to impede enemy attack. Second, that the tactic was motivated by an effort to bait the enemy force into launching an attack that would expose the shields to a substantial risk of death or injury. And third, that the attack was lawful under the circumstances. The following part examines these essential findings more fully. That's where you delineate these in far greater detail. Talk to us about the centrality of those three criteria in the relevance of this paper, if you would, and if you would conclude, we'd be very grateful.
Yeah, well, I mean, first off, this has been very helpful. I'm starting to think I may change the title a little bit. I think what I'm talking about may be an aggravated form of human shielding. So not necessarily separated from human shielding, but to demonstrate that human shielding can have two purposes. One would be to prevent the attack. The other would be to bait the attack. And the baiting method of human shielding is a more aggravated form of human shielding. Ellie raises a good point. The idea that the enemy leading you into attacking their own civilians is not nullified because your attack turns out to be unlawful. But I think the problem with that is one of the things I'm trying to do here is prioritize or maybe incentivize the articulation of attack legality for the friendly forces, because that's what shifts the focal point of legal and moral responsibility to the enemy. And that's one of the big objectives here. And that's why the idea is, to characterize it for what it really is. I think Ellie's right. That's an uphill battle because the international community likes images and they like effects-based condemnations, but it doesn't mean we should give up the fight. And if we can have better, more logical ways of explaining what happened, it produces a positive benefit. And what we want to explain is civilians were harmed. It's the enemy's fault. We did everything we could to avoid it, but in war, there are times when you have to attack even knowing that it's going to result in civilian casualties. So point the finger of accusation at the other side. They're the ones who are really responsible for the attack on the civilians. If they hadn't kept the civilians there, we wouldn't have had to endanger them when we launched the attack. And I would also say on your question about Europe, I think we have to be very careful. I mean, the playbook of using the exploitation of civilians, particularly in urban environments, to undermine the legitimacy of otherwise lawful military operations is certainly being studied by other enemies. And if there's one Achilles heel of the NATO alliance, it's unity or maybe disunity. So let's all pray that this is all hypothetical. But if there were a hot war between NATO and the Russian Federation, it certainly is in the interest of the Russian Federation to create the public perception of indiscriminate attacks on civilians by the NATO forces. That's either going to slow them down or it's going to drive divisions between the alliance. So NATO certainly, and the NATO forces ought to be thinking about how can we execute our military operations against an enemy that exploits the civilian population illicitly and do it in a way that attributes responsibility for that exploitation where it belongs.
Well, thank you so very much. I want to thank my colleagues. I want to thank Rosita Panini, the co-founder of our institute, and also Alan Langer for bringing this together. This has been a wonderfully informative panel, and I really do champion and endorse the ethos with which you brought it for conversation, Professor Korn, which was to submit your thoughts, have it bandied about, have it bounced about, and then refined. And I think that that's an example that everybody should emulate. I also want to tell people who are not of legal backgrounds, the issues you're tackling and that the panelists have tackled, Colonel Collins and Colonel Baron and Professor Knoops, these go to the heart of issues that are very, very close to the hearts of all of us. Protecting the troops, thanking troops for their service, endorsing the good names of the members of the Israel Defense Forces and the US military and other militaries as well. And I just want to applaud all of you for assigning the best of your time and your talent to these important subjects. They need to be debated, and I very much enjoyed the idea of you taking it almost from a defensive posture where the allegation is made, to an offensive posture, to pointing the finger back at those who are engaged in what you have called the targeting of innocent civilians. It's been wonderful for me to learn from all of you. You've all continued my education. I'm sure everybody on the call is enriched. I have one question from David Levitt. Where can one find your paper, Professor Korn, and when am I at liberty to disseminate it?
So it's still under editorial work. It's going to be published by something called the International Law Series by the Naval Justice School, the Naval War College. And what I'll do is, when I've got a version that I can publish on the Social Science Research Network, I'll send it to Benjamin, or on a mailing list or something. He can share it with anybody who's interested in it.
We would
You
love.
can, by the way, you can find all of I've written a lot on these subjects, a lot of other stuff. If you Google my name and SSRN, Social Science Research Network, you can get access to everything I've published.
Thank you so very much. Thank you again to all of you. I'm so very pleased to have been able to bring this together. It's been a privilege for me, and I look forward to learning more about the progress and the advancements of this paper and the ideas contained within. Thank you, all of you, indeed.
Thank you.